Thank you, Judge Kidd. For those who are here with the nominees and have not been through this process before, it is an interesting exercise. Men and women come before us hoping for lifetime appointments to the federal bench. They are questioned about their backgrounds, their competence, their integrity, and their record under the law. Judge Kidd, you bring one of the most lengthy records I can recall. 13,700 decisions. Amazing. Reversed 9 times. 9 times out of 13,700. That's quite a record. The American Bar Association asked lawyers and professionals in your community what they thought of your performance as a judge, and let me read what they said. The Standing Committee of the American Bar Association has the unanimous opinion that Magistrate Judge Kidd is well qualified to serve on the U.S. Court of Appeals for the 11th Circuit. That's a good starting point. Having said that, expect that at least 2 or 3 of the decisions which you reach will be very controversial and raised in this committee. That is part of the process. I know you're prepared for that. So let's start in with the question, if I can, in terms of 2 cases. U.S. versus Dady. Do you recall that case?
Yes, Senator.
Explain to me what your ruling was in that case.
In United States versus Dady, I saw the defendant at an initial appearance, and at that case, it was at that time it was on a criminal complaint, and my involvement in the case was really that initial appearance and a detention hearing. At which time, at the initial complaint stage, he had been charged with 1 count of possession of child pornography. After hearing that evidence from the government, I placed the defendant on home detention, house arrest. So he couldn't leave his residence without court's permission. He was on GPS monitoring, no contact with the victims or with any other minors. And subsequent to that, the defendant was indicted with 2 additional charges of enticement of a minor for 2 different victims. The government sought a review of that decision with the district court and presented additional evidence to the district court that was not before me, and the district court decided to detain the defendant, and then I think he was ultimately convicted of those crimes.
So your home confinement for pretrial was under charges that changed dramatically after. Is that correct?
That's correct, Senator. In addition, at the time that I saw the defendant, there was no statutory presumption that he should be detained based on the charges that he was ultimately indicted for. At the time that the district judge saw the defendant, there was a statutory presumption that he should be detained.
U.S. versus King. Could you explain your decision in that case?
In United States versus King, the defendant, I believe, had been charged with possession of child pornography. At the detention hearing, after hearing evidence from the government and hearing argument from both sides, this was another individual that I placed on house arrest with similar conditions, could not leave the residence without court permission. He was on GPS monitoring. He could have no contact with the victims or with any other minors. And in that case, the government, again, presented additional evidence to the district judge. And the district judge noted on the record that that additional evidence persuaded her that the defendant should be detained. And he was ultimately, I believe he was ultimately convicted of those charges.
So the charges against this defendant, after you initially put the home confinement requirement, changed and were increased in the district court, made a decision based on those new charges. Is that correct?
Senator, I believe in that case there was an indictment. I'm not sure if there was a superseding indictment afterward, but the government presented additional information to the district judge based on my review of the transcript regarding the defendant's compulsions, and that caused the district judge great concern. That information was not presented to me. I'd
like to ask you, in the minute remaining, if you can, to summarize your involvement in the Joel Greenberg case?
In the Joel Greenberg case, I was not the magistrate judge assigned to the ultimate case, but I was the magistrate judge who saw Mr. Greenberg at his initial appearance, and I set his conditions of release. At some point, Mr. Greenberg violated the conditions of his release, and I ordered him detained based on that violation.
Thank you. Senator Lee?
Thank you.